Justice Biles, sound check, 1, 2. Justice Rosen, sound check, 1, 2. Justice Lukert, sound check, 1, 2. Chief Justice Nuss, sound check, 1, 2. Justice Beyer, sound check, 1, 2. Justice Johnson, sound check, 1, 2. Justice Stiegel, sound check, 1, 2, 1, 2. Podium sound check, middle, 1, 2. Sound check right, 1, 2. Podium right, 1, 2. Podium left, 1, 2. Podium left, 1, 2. Podium sound check, 1, 2, 3, 3, 2, 1. Podium sound check, 1, 2, 3, 3, 2, 1. Podium sound check, 1, 2, 3, 3, 2, 1. Podium sound check, 1, 2, 3, 3, 2, 1. Podium sound check, 1, 2, 3, 3, 2, 1. Podium sound check, 1, 2, 3, 3, 2, 1. The docket for Wednesday, January 24th, 2018 consists of 4 cases. First case, appeal number 116818, Sally A. Scribner versus Board of Education of USD number 492, Butler County, briefs both sides.
David Schauner, appearing on behalf of the appellants, present and ready for argument.
Robert Baltus, on behalf of the appellants, present and ready for argument.
Ed Keeley, appearing on behalf of the defendant, School District 492, appellee, ready for argument.
Assistant Solicitor General Dwight Carswell, appearing on behalf of the state of Kansas, present and ready for argument.
Second case, appeal number 106741, State of Kansas versus Thomas E. Jenkins, Saline County, briefs both sides.
Gerald Lee Wells, Lawrence, present and representing Mr. Jenkins, the appellant.
May it please the court, Ellen Mitchell, Saline County Attorney, representing the state of Kansas, the appellee, present and ready for argument.
Third case, appeal number 108625, State of Kansas versus Dana L. Chandler, Shawnee County, briefs both sides.
Stacy Schlimmer on behalf of the appellant, Dana Chandler, present and ready to argue.
May it please the court, the state appears by Assistant Solicitor General Jody Lippman, present and ready for argument.
Final case, appeal number 118204, in the matter of Matthew Edgar Holt, original action and discipline, no briefs filed.
May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator, present and ready for argument.
May it please the court, Matthew Hall, appearing pro se, present and ready for argument.
Your Honor, that concludes the docket for today.
Thank you, Mr. Shema. Before we proceed, I do acknowledge there is at least one organized group of people in the audience. The person that I know from that group is First Sergeant Ewan. If he could stand and tell us who these folks are.
Good morning, Your Honor, members of the Supreme Court. My name is First Sergeant Ewan. I bring into the courtroom today 45 high school ROTC cadets and middle school leadership cadets from Wichita, Kansas. Part of our mission there in Wichita ROTC is to develop citizenship and civic responsibility. We bring them into your courtroom today, Your Honor, to kind of continue that training. On behalf of our director, Colonel Kennedy, thank you for allowing us into the courtroom today.
Thank you, First Sergeant Ewan. It's our pleasure. Thank you all for attending. Any other organized groups besides just interested individuals? Very well. Proceed to call the first case on the docket. Case number 116818, Sally Scribner v. Board of Education of USD number 492 et al.
If it please the court, my name is David Schauner, appearing on behalf of the appellant. And before I forget, I'd like to reserve 5 minutes for rebuttal.
5 minutes is granted.
Thank you. This matter arises today as an appeal from the Butler County District Court and arises out of an action taken by the Kansas legislature in 2014, amending the Kansas due process statutes that apply to certified teachers in Kansas K through 12. That matter was challenged in the district court in Butler County, and the court there found adverse to the appellant. We're here today to ask this court to review the underlying facts and the constitutionality of the statute, and we're prepared for argument. This matter arose in April of 2014, and it arose in an odd sort of way. The legislature was under the gun, so to speak, to pass some funding legislation in response to the court's decision in Gannon. On the 3rd of, early in April of 2014, House Bill 2506 was enrolled. There were hearings, and that bill was a bill to talk about making some changes in the Midwest Higher Education Compact. However, on the 3rd of April that year, that bill was gutted and substituted for what became known as Senate Substitute for House Bill 2506. That bill was then amended a number of times by interested parties, and the one that we're here today and concerned about is the amendment offered by Senator Arpke on Friday, April 3rd. And that amendment had the following impact. It changed the definition of teacher and removed from that definition those persons who were employed by a K-12 school district. It left intact coverage, due process coverage, for those persons who were working for a community college or a technical college. The impact of that was that all of those persons who had earned a tenured position, property if you will, were no longer holders of that property. So I would start with, my first question is, were these folks tenured? My two clients were highly qualified veteran teachers in Kansas, had earned due process rights, and I submit to you that they had earned a property interest in that employment.
Counsel, in that regard, are you familiar with the case out of North Carolina from a couple of years ago that talked about the continuing contract law and basically I would read it as supporting your position? You didn't cite it in here. So my first question is, are you aware of the case?
Oh, absolutely, I am aware
so
of the case.
now my question is, how is the case that you're presenting to us different from that case?
Well,
I guess I'm trying to say I'm surprised those arguments aren't here.
it was our opinion that the contract provisions in North Carolina were different than the contract provisions which might be available to teachers in Kansas. But rather, in Kansas, there is a strong property interest that was taken from these plaintiffs by action of the legislature without either notice or opportunity to be heard on the substantive matter of their property loss. Essentially, a taking without notice or opportunity to respond.
So from that, I don't know quite how to ask this, so bear with me, but it doesn't seem to me like your case is predicated on the provisions of your client's actual contract.
I believe that to be accurate.
Okay, okay. And then just one final thing. So there's nothing in these teachers' contracts that we would look to. The chronology that I have is that this law is published in the Kansas Register on May 1st, but the statutory deadline for the school district to give notice to these teachers was May 15th of 2014, but 2506 provisions as to the teacher provisions didn't go into effect until July. So what I'm getting at is on May 15th of 2014, is there any reason to believe the old law embedded into the contract for the 2014-2015 school year? You get what I'm
I do. I think the closest reference would be the continuing contract law. And the notice, the concept of a notice on an annual basis by a fixed statutory day, a calendar date, is there to give notice to the teacher, whether they're tenured or not, that their contract's not going to be renewed for the following school year. There's nothing embedded directly in these appellants' contracts that say you have a property interest, but rather...
Or nothing that says we're putting into the 2014-2015 contract the law as it existed on May 15th. You see what I'm getting at?
That's correct. That's correct.
There's nothing in that contract that
that
would grab that law, other than the constitutional arguments that you're making.
That's correct. The action in this case took place at the close of the 14-15 school year, not at the close of the 13-14 school year. So the statutory date had already passed at the close of the 13-14 school year before this statute was passed.
The effective date preceded the termination of your clients.
It followed well, let's back up. In 2014, the statutory date for notice had passed. But for the 15 notice date, the statute was in place and had been effectively since July 1st of 2014.
Your clients were not terminated until that period of time.
That's correct. So one of the fundamental questions here is, if you believe, as I do, and as I believe this court has said many, many times since 1974, that teachers, after they serve a requisite number of years, earn a property right. And I'd refer you clearly to the
Before you
McMillan
go
case.
into that, can I back up just a minute? Because I'm trying to figure out what your answers to the Justice Biles questions does to your second issue. Are you basically conceding your second issue?
I think our strongest issue is our property interest issue. The other side, the appellee here would have you believe two things. One, that under KSA 725444, these folks can never earn a property right or a contract right. Secondly, that these changes enacted in April of 2014 operated only prospectively and didn't have any impact, or rather, it did have an impact on my clients, but not an adverse action, because their only due process would have been available to them in a prospective manner. We disagree wholeheartedly with both of those contentions. In fact, this statute does have a retrospective, or retroactive rather, application. It takes away property that these clients had earned through their quality service to the school district. And they never had either notice or opportunity to respond to these changes in the law, which occurred in the wee hours of the morning of Saturday and Sunday of April 5th and 6th, 2014.
Is the problem the timing? The timing that Senator Arpke's amendment was offered didn't afford that? Had the amendment been offered earlier in the session when there was time to discuss this, presented at various committees, would that have satisfied due process in terms of the taking?
I think that there is reason to believe that had there been proper notice and opportunity, that under a reading of 5444, there could have been a change in the property interest status of my clients. That did not happen, however.
I understand, but that could have happened given that typically we look to the legislative process to satisfy the due process requirements.
But there's this broad thing called legislative process, which is just a whole lot of stuff going on over there, and that's all sort of process. But legislative process in this case, under the Darling analysis, has to be more than just the legislature says yes and no. There has to be, under the 14th Amendment and under our Kansas Constitution, Articles 1 and 2, notice and reasonable opportunity to respond before property is taken, whether it's life, liberty, or your property. And clearly in this case, this court has ruled on a number of occasions, McMillan being one, Coates another, that there is a property interest earned by these teachers through quality, continuous service.
Do you concede that the legislature has the power and authority to eliminate this particular property interest?
Not unbridled.
Well, can they, under any circumstance, eliminate this property interest?
The legislature, once it gave this property to these folks as far back as 1974, reserved to itself the right to make changes in that.
So your answer is yes, the legislature has the power to eliminate the property interest that they granted.
My answer is, with proper safeguards, they had...
But the first question is, do they have the power to ever eliminate that interest?
With proper...
That's the preliminary question.
With proper safeguards, the answer is yes.
The answer is yes. So that leads me to my second question. What is it you are saying the legislature had to do in order to properly exercise that authority to eliminate the property interest?
They had to provide notice, not individual notice to my two clients, but notice generally through their regular scheme of notifying the public about what they were doing. And
how do we know what their regular scheme is? I mean, why didn't this occur within the regular course of what they do?
Well, being cynical, I think they did it this way because it was sort of a midnight raid on these rights.
But whether it's cynical or not, we know the legislature often passes laws, quote unquote, this way.
It isn't just a matter of passing a law. It's a matter of taking somebody's property. That's different.
Well, but you've conceded that they have the power to take the property in response to my colleague's question, and you're complaining about the process.
I'm complaining about the form of the question because it's not just that they have power, it's that they must exercise it in a way that's consistent with the 14th Amendment and the Kansas Constitution, Articles 1 and 2. And they did not do that in this case.
What does the 14th Amendment require of a legislative body in order to legitimately exercise its power?
I believe the framers had a general fear of government. And they said in the the 14th Amendment and the 5th, as it applies to the federal government, you can't take someone's life or their liberty or their property without proper procedures, a notice and an opportunity to be heard. And the amount of all those things varies with the level of taking. In this case, having a legitimate fear of government is wise, because in this case, after regular business hours for most human beings, the legislature met on a weekend, in the middle of the night, amended this.
Is there any case in the country that says the 14th Amendment doesn't allow a state legislature to pass legislation in the middle of the night? That's not sufficient process.
It isn't just when they did it.
Well, is there any case in the country that holds the way you're asking us to hold?
Well, I can't cite you a case on those specific facts, but what I can cite you is a litany of cases which say that a bare legislative process in a taking without proper notice and opportunity to at least the class of persons that will be affected violates the 14th Amendment due process considerations.
So to go back to what the minimum that the legislature had to do to satisfy the 14th Amendment, what are those things?
Notice, reasonable notice.
And you've talked about general notice to blank. Who does it have to go to?
Well, to the public. The notice that they give to any citizen isn't necessarily particularized notice. They don't have to send it to David Shawner, but they have to put it out there in some way that I have an opportunity, if interested, to know about it.
In what way would that be?
Through their, now through websites, through their own website, through their own processes. In this case, they did nothing. They didn't do anything. It's not a matter of what were their processes. They didn't exercise a process other than a late on Friday amendment to a gut-and-go bill, a bill that they gutted and went with, changing the whole subject of it. It was a must-pass bill. They ended up locking up the House chambers so nobody could leave because they couldn't come up with a 63rd vote. I mean, this was run through without any regard for whether anybody whose property was being taken would have an opportunity to respond. Before it was a fait accompli. And that's exactly what they did.
And to go back to Justice Steagall's point, the gut and go, whether you like it or not, has been used rather frequently by the Kansas legislature, at least in recent years. Would you agree with that?
I would.
Okay. You take exception to their use of that device under these facts because a property interest was involved? Is that what you're telling us?
I would take issue with any process, gut and go or otherwise, that was intended to take my property and didn't at least give this class of folks a notice about it and an opportunity to weigh in.
So the 14th Amendment requires hearings. That's
No,
boiled down what you're
well, it
saying.
requires notice and opportunity to respond.
And
Not
that-
necessarily
what-
a hearing.
Well, is there any other,
Well,
would any other process satisfy your
Well,
position?
I don't want to get hung up on how finite the process has to be. I think the notion is you look at the kind of process that was available in the context of what was being taken. And what was being taken was, in the case of my two clients, their livelihood.
We're trying to find out, I'm sorry.
That's all.
Going back to my original question, we're trying to find out what is the minimum that the Kansas legislature could have done or should have done to satisfy your due process concerns. You've talked about general notice to the class of people whose property interest is being taken. Justice Stegall asked you, well, is a hearing required? And you said, I don't want to get into the niceties. Well, I'm asking you to get into the niceties. What besides notice would be required to satisfy your view of the 14th Amendment?
Let me try this as a response. If there had been a notice in the regular course of business, we get notices all the time about a bill that's been introduced on some subject. If it had happened in that way and there had been a hearing scheduled, could have been a short hearing, but a hearing scheduled, and we'd had an opportunity to respond to it, that would have satisfied the notice and opportunity. But the problem...
I'm asking what the minimum is.
I think that would be the minimum. I think that would be the minimum.
Wasn't there opportunity for debate on the floor?
There was
of
not.
each house?
Well, there was opportunity for debate among the legislators, but there was no opportunity for input from those whose property was being taken.
But isn't there quite a bit of case law saying that that type of hearing where the public speaks is not critical or isn't a requisite to due process in the legislative process?
I don't believe that's the rule.
You don't think Onyx from the 10th Circuit and other cases stand for
I
that?
don't think that in these facts that would suffice.
So these facts being where you have a property interest at stake?
Yes, ma'am.
Is that the distinction you
Yes,
make?
Your Honor.
And your best case for that proposition would be what?
For the proposition that they needed more than just legislative action generally?
When there is a property interest at stake, yes.
I think that if, again, going back to the founders' general fear of government, if legislative action can pass lots of things to take care of the state's general business, paving roads and that sort of thing, I think the standard for legislative conduct is significantly lower than legislative conduct which is designed to take either my life, my liberty, or my property. And I think by virtue of that, it's not possible to come up with a specific, they have to do A, B, C, and D. I think rather what they must do is contextual. And the more if they're going to take my life, then I believe they have to do more than if they're just going to take my property. If they're going to take my liberty, I think it's a higher standard than if they're going to take my property. But taking my property is not insignificant. Whether it's my house, my job, my car, my bank account, all of that is my property and deserves more than a weekend rush to judgment on an amendment of a gutted bill. It isn't just that they used the gutted bill, it's the lack of any notice whatsoever to these plaintiffs or anyone else like them. I mean, we're talking about a class that exceeds 25,000 people.
So the answer to my question, what is the best case you have to support your position? You've not given me a case, but rather reasoned from our founding fathers' desires. Is there such a case you can rely on? What is the best case so we can look at it in detail?
Well, I think the best case would be your own decision, in this court's decision in McMillan, and all the other cases that we've listed in our brief. And in that case, it says, quote, once the state has conferred a property interest, the property interest cannot be taken without constitutional procedural due process. In Kansas, a public employee who may be discharged only for cause has a property interest in continued employment. We agree with Macmillan that a tenured teacher's right to continued employment is a property interest subject to the protections of due process. There was no due process in what the legislature did. They just did it essentially in the middle of the night with the basic precepts of the 14th Amendment are notice and opportunity to be heard.
Counsel, how is the standard you're proposing manageable at all? Because, I mean, you just suggested, for example, that a deprivation of a liberty interest actually would require more process than what you're advocating for. But virtually every law passed by the legislature, in some sense, constrains liberty. It strikes me that you're suggesting that the entire manner in which the legislative body goes about its business is inadequate.
That's not my position. I think that would be a significant expansion of my position. And I think the truth of the matter is that one of the roles of this court is to look at what the legislature did, to determine in this court's eyes and analysis whether what they did met the standard. That's always been the way it worked. The legislature does what it does at its risk for being right or wrong.
Well, let's say the legislature reduces the speed limit on the highway to 55 miles per hour. And I'm a person who really likes to drive 70 miles per hour. And they did it in the middle of the night. Like, did I have a right to be heard on that?
No, you have a right to challenge the ticket.
But I didn't have a right to have a legislative hearing and talk about, don't deprive me of my liberties.
I have a strong hunch that if they were going to lower the speed limit and they told people about it, there'd be a whole lot of folks over there complaining. If they lowered the speed limit and didn't tell anybody about it, there'd be a whole lot more people over there or here. But it requires something.
So the Constitution does protect the citizens' rights to weigh in on that issue.
I certainly hope so. Okay. I believe so. I've always believed so. I mean, the constitutional bedrock for takings and the prohibition on takings without significant process, if we don't have that, then we really don't have much.
Is the legal problem for you, and I don't remember the citation, but the statute where the legislature reserves the right to be able to change the Due Process Act? Because if you didn't have that, you'd be arguing that your clients earned their statutory protection. There was no reservation of the right to that, and so it's embedded in the continuing contract for their professional career.
See,
and is that the distinction between Kansas and, let's just say, the North Carolina case or something like that? It seems weird to be talking about the legislative process of notice and opportunity to be heard with this as opposed to this being a violation of the contract clause.
Well,
I can't get over that.
We believed when we filed this lawsuit, and I continue to believe, that even though 5444 attempts to reserve certain rights to the legislature around property interest and contract rights, that reservation is not exercisable without due process.
But it is exercisable.
Yes.
Okay.
But they exercised it here in a way that didn't satisfy due process. They just did it.
You're well out, but I have a question, and I appreciate it that it's in the context of what you're arguing here is that the guarantee of teacher protections has been stripped away from you. But is there anything that prevents individual bargaining units from negotiating these same protections or even greater protections with their local school boards and through their contracts that way?
There's nothing to prevent all kinds of rights in a bargained agreement. The problem is that effort's been made in a number of school districts across the state with very, very limited success. So what we now have are diverse classes of protection.
So that's so the current kind of climate here is there's differing protections depending on where you're employed.
From at will to something that approaches what was there before.
Okay.
Do you have any further questions? Counsel, we've peppered you with questions. Do you need 30 seconds to wrap up your position, or you want to wait till rebuttal?
I'll wait till rebuttal.
Very well, thank you.
May it please the court. My name is Ed Keeley. I'm here representing the defendant, Eppley School District number 492. I'm going to split my time with the intervener state, Mr. Carswell. The plan is that I would take the first 7.5 minutes and then turn it over to Mr. Carswell. Procedurally, this case was filed against the school district, challenging the constitutionality of the 2014 amendments. And then at a point then after it got started, but not too far, the Attorney General's office moved to intervene. That was granted. The Attorney General's office, although we have some minor differences in our positions, basically supports the position of the school district that the 2014 amendments are constitutional. And the legislature, this year, could go back and legislate again and go back to the old system if it wanted to. It's a legislative prerogative. It's a policy matter. It's these so-called tenure rights are not constitutional rights under the Kansas Constitution. They were statutory rights. And it's been pointed out.
But they were property interests. I understood you weren't challenging that there was a property interest.
I'm not challenging it. I think
Well, I understand that. That's one of the minor differences.
I'm not challenging that before the 2014 amendments, based on decisions of this court and the way the statute had evolved from when it first was, or the act was first enacted in 1974, that this court at times had said, yeah, because the court had construed it to mean that termination or renewal only for good cause, that there was a property interest. But the property interest was found in the statute, the teacher statutes. What I'm arguing is, and it's based on KSA 725444, but I would say that even if without that statute, but that statute is the specific one that says, it was said at the very beginning when the tenure, which wasn't tenure to begin with, it was more of if there's disputes, there can be a grievance board, or there can be some advisory or recommendations to the school board, and then over the years it built into more protections for teachers. But from the very beginning, the statute 725444 said there's nothing in this act that creates any right or contract right. And so it's obvious, and it can be changed or repealed at any time. We're not trying to create something that's going to last forever.
Well, there hasn't been a notion, as I recall in the law, and correct me if I'm wrong, that the school district could change mid-school year. Once you got past May 15th, you had a new contract, and that contract is property right. No one can dispute that. So it's not like you could come in the middle of that contract year and change the terms. You're picking it up at renewal, and then either give notice or you don't. If you don't give notice, you're stuck. And that's still the part of the law. So I don't think it's accurate to say that you can change these contract rights at any time. Do you agree with that?
I agree that you can't change them. Well, let me address this because I think it goes to the whole retroactive versus prospective and the timeline. The 2014 amendments were were adopted in April of 2014. They didn't become law then, but, and it was, I want to emphasize, they were voted on by both houses, the House and the Senate, approved by both, by the representative of the elected representatives for the people. We have a Republican or representative government that's, we elect these legislators to make those decisions. Both houses approved it in these amendments in April 2014. It was signed, I think, by the governor maybe in May, but to be effective July 1 of 2014. Okay? So there wasn't any effective date of the 2014 amendments until July 1, 2014. What happened in this case didn't happen until 9 months later and these were one-year contracts. And so it didn't affect that contract then for 2014, 2015 for the plaintiffs. But when they were coming up to whether there was going to be a contract for 2015, 2016, then the law still says that on the May date, if you're going to non-renew, you still have to give them notice of your intent to non-renew. What is different now is that you don't have to give them the reasons, written reasons, or you don't have to give them an opportunity for a hearing. But you still had to give them notice. And so it was prospective. It wasn't, everything happened and was intended to happen after July 1 of 2014. And so it wasn't like July 1, 2014, and the legislation looked backward and took away some rights. But certainly after it became effective July 1, 2014, at that point in time, the statutes, because of the amendments, were that there was this, renewal system that was different than the prior one. And one of their arguments is that, well, the school district should have known it was unconstitutional and should have used the old system, but the old system didn't even exist. It wasn't even in the statute books. So, but yes, you can change. You can't change something, retroactively from the effective date back, but you can certainly, as the example was about the speeding change. The legislature goes in and changes a 75 mile per hour speed limit to 55. Before the effective date, I can go 75. In one sense, I have a right to go 75 without getting a ticket. After that date, I can't go 75. It's affected my rights. But nobody can go back from the date of the effective date and say, well, you did 75 before that, and therefore you get a ticket. That's retroactive. But prospective is from the date of the effective act, which is virtually all acts have an effective date. They don't take in effect until that date, and then they apply to everybody, and somebody gets hurt. Somebody has advantages under the new law. Somebody has disadvantages. That's what happened here. And so it's based on the timeline, there was certainly no retroactive effect. They were under the new law after the effective date. Now, one thing I do want to point out before, because there's been a reference to this North Carolina case, which, as I understand it, and I didn't really even research it because it's never been an issue here, but the North Carolina case was totally argued based on the U.S. Constitution contract clause, not the due process clause. It was never raised in the petition here. It was never argued in the cross-summary judgments here to Judge Hart. It's never been an issue here, and it can't be an issue here on appeal. This has solely been an issue on the due process theory of unconstitutionality. So I wanted to make that plain.
Before you sit down, what teacher protections in USD 429 currently exist? What protects a teacher from a solely arbitrary discharge? Are there any?
under number 4, my client, 492.
Yeah, aren't you here? Yes, your
Yes.
client, I'm sorry.
Yeah.
I meant,
to be honest with you,
492.
Yeah, to be honest with you, I don't know because I don't get involved in their teacher
I
contracts.
thought you were representing their.
For this case only.
All right, so you don't know that.
I don't know. I agree with that the act allows that bargaining. There's nothing in there that prohibits the bargaining of the district for protections.
But right now, you don't know if anything exists to protect from arbitrary
I don't.
discharge. Okay.
I don't, sir.
Counsel, I'd like to go back to the issue that we addressed with opposing counsel. And we had asked him concerning this particular legislative process, what else needed to be done to satisfy his 14th Amendment argument. My question to you is, did the legislature, in your view, do the absolute minimum to satisfy the 14th Amendment, or could they have done even less than they did here and still be all right?
Well, they certainly did, based on the U.S. Supreme Court cases and the Onyx 10th Circuit case, where it's not required to have a legislative hearing, where it's not required to have a notice broadly. I mean, those things certainly apply in a judicial sitting, an administrative, where there's two parties that are, and there's a determination, a quasi-judicial or judicial determination of whether a property or liberty is taken. But in a legislative situation, it was certainly enough for the...
I understand you said it's enough. Could they have done less and still satisfy the 14th Amendment?
I don't know. I haven't thought of it that way.
Well, let's ask this: do they have to do anything?
They have to vote on it. They have to.
No, I mean, do they have to do anything?
I would say they have to debate it.
Counselor, let me ask my question, please.
I'm sorry.
Do they have to do any notice to anyone, or grant opportunity for hearing to anyone?
Well, I would say no. I would say to have the courthouse.
That would lead us to the point that no matter how incredibly stupid we think the law might be, we have to send them back to the ballot box. That's the only relief they have. They don't have any constitutional relief here. That's what you're saying.
Well, based on the U.S. Supreme Court decisions, I mean, and again, that would go to whether this court doesn't get into policy matters that the legislature is whether it's wise or not. But certainly they have to. I mean, the legislature, I mean, it has to be open. Anyone can attend, listen to them, have access to their own legislator. But do they have to publish it in a paper? I mean, what notice are we talking about? We have to send out emails to everybody on a list? We have to, I mean...
Counsel, let me give you an example. A bill comes over from the Senate to the House. On the floor of the House, it's amended to put these provisions in. The bill then goes to conference committee. The House and Senate conference committee concurs, and it goes then it goes back, voted on, and up to the governor. There's never a hearing. Is that good enough?
Yes, sir. Under current law, under U.S. constitutional law, because you would. I mean, there's so many bills that are passed that way every session, because it's just the nature of legislative process that as you get closer to the end of the session, there's taken from this bill, that bill. You as long as you have debate of your elected legislators and they vote up or down, they voted up and pass it, then that's sufficient due process under the legislative session, except for a situation like Darling, where that was a specific legislation targeting a few specifically identified individuals for termination. That is a defect, but it didn't really have it didn't have anything about notice or hearing in that per se. It was basically legislation that targeted specific individuals, not a general class. I'd like to, unless there's questions.
Does that change your answer to that if, based on the subject matter of the bill? I mean, if we're announcing a new state bird at midnight or whatever, as opposed to depriving a property interest, does that change the nature of the process? Or is it the same regardless of the subject matter of the bill?
To me, it's the same. I mean, whether it's the 55, 75 mile per hour, whether it's the state turtle, bird, I mean, these, we're talking about state statutes, not the Kansas Constitution. So state statutes in general are there to be modified, repealed, replaced every legislative session. Thank you.
Thank you.
May it please the Court, Assistant Solicitor General Dwight Carswell appearing on behalf of the state of Kansas. The U.S. Supreme Court long ago established that when legislation affects a general class of people, the legislative process provides all the process that's due. Courts across the country have applied that rule to reject due process challenges to legislation eliminating tenure or civil service protections for public employees. And that same rule requires the rejection of plaintiffs' arguments here. Plaintiffs try to argue that there's some exception to that rule when there's a defect in the legislative process. As an additional matter, their original source for their argument there is the Supreme Court's decision in Atkins v. Parker. What the U.S. Supreme Court said there was they, the petitioners, do not claim that there is any defect in the legislative process. So the U.S. Supreme Court was just saying that issue wasn't raised there. It wasn't establishing a defect rule. But in any event, the U.S. Supreme Court has also been clear that legislatures are not required to hold hearings on legislation. And so that forecloses plaintiffs' defect argument.
Counsel, you would agree that when you get past the date in May, third Friday or Monday or whatever it is, I'm saying the 15th, but when you get past that day in May and you've got a contract for the next school year, the legislature can't change that contract during that school year, correct? Because that's a property right, to have that contract for that school year.
Well, whether it's a property interest depends to some extent on the terms of the contract. The U.S. Supreme Court's been clear that at-will contracts, for instance, don't.
Well, there wouldn't be anything at will in a contract for a term, for a school year. So the legislature can't change the terms of that contract by legislation mid-school year.
I think that would be a contracts clause issue rather than due process, but yes, I think that's correct.
Well, right now we're just talking about property interest.
Well, again, I don't think, the U.S. Supreme Court's discussion of property interest in the context of the 14th Amendment looks at whether a particular contract is at will or whether you have tenure. So I can't say categorically that every contract would confer property interest.
Well,
it would be a contract,
a term contract isn't at will. It's for a term.
I mean, if it provides you can be fired at any
time,
that's an
it's at will, but for a term, it's a term. Okay.
Do you disagree with your co-counsel on what the minimum would be required here for the legislature to meet the due process requirements?
I think we agree, if I heard him right. I mean, the minimum is just whatever's required as a matter of state constitutional law to pass legislation. The due process clause doesn't prescribe any particular procedures. It leaves it to states. And as long as, in this case, bicameralism, presentment, those sort of things were satisfied, the single subject rule, for instance. As long as it's validly enacted as a matter of state law, and it goes through the legislative process established by state law, the U.S. Supreme Court's decision in bimetallic and subsequent cases says that's enough.
Very well.
So my example of a floor amendment to the other house's bill and concurring and then going into conference committee and on, that's just fine.
That would satisfy due process. Yes. And in fact, there are a lot of property rights that are treated like that. I mean, if you think about it at the federal level, tax legislation, taxes affect property interests. Those can be settled in conference committee without hearings, especially if you think at the federal level. I mean, it happens quite a bit, and the U.S. Supreme Court's never held that sort of thing violates the due process clause. Plaintiff's reliance on Darling is also misplaced. The court there recognized the general rule, but said that case involves unique set of facts. It involves 17 particular individuals who were terminated for termination. That's clearly not the case here. That case was more like the Londoner case that the U.S. Supreme Court distinguished in bimetallic. Here, the bimetallic rule that the legislative process provides all the process that is due controls. The state also argued below that the plaintiffs didn't have a due property interest in the first place. The district court obviously didn't need to address that, given its holding. Neither do you. You could easily affirm the district court on the grounds that it gave. But if for some reason you were struggling with that rule, you could and should address whether they had a property interest. Given the time limitations, I'll just rest on my briefs on that point unless you have any questions.
Any more questions of council? All right, thank you, council.
Thank you.
And you reserve 5 minutes for rebuttal.
I'd like to respond to the inquiry from the court earlier and cite to you from our brief on page 2 that, and I'm referring to the case of Atkins v. Parker, 472 U.S. 115 at page 130. The question is whether legislative process is sufficient. Quote, "This rule does not eviscerate all due process rights of plaintiff here. A federal interest remains in protecting the individual citizen from state action that is wholly arbitrary or irrational," citing Logan. "Similarly, an individual claiming a defect in the legislative process might have a claim for due process violations. Likewise, in the Gaddis case, which we cite on the same page, the court in Atkins held that absent some identified defect in the legislative process, a legislature has the power to modify or rescind property interests previously conferred." It's one thing for the legislature to bequeath or give a property interest. This court has acknowledged multiple times that teachers serving the proper number of years have a property interest. That cannot be at issue here. The question then is, what process must the legislature use to take away the property right they vested in those individuals? I suggest to you our brief supports my contention, my belief that what they did in this case did not meet the minimum. In fact, it's hard for me to imagine there could be less legislative process in this taking than was given. There was no process other than a locked room, middle of the weekend, and no notice and no opportunity. It is a classic example of taking the affected folks out of the equation.
As I understand your response to some of the questions about the timing, there was another legislative session between when this legislation became effective and when notice was given to the two plaintiffs in this case. Is that correct?
I was trying to remember earlier. I think the notice date for non-renewal. Well, yes, you're correct. In 2015, there was another legislative session. My clients were not non-renewed until the spring of 2015. So the answer is yes to your question.
And so why does not the fact that there was that legislative session where there was an opportunity for additional hearings, legislation, and I know there's been legislation proposed since 2014. I don't remember if it was anything in the 2015 session or not. But does that undercut your argument? Because there was still an opportunity for your plaintiffs and other teachers across the state to push this issue in the legislature in that 15 session?
I don't think so. I don't think it undercuts our argument at all for this reason. They took their action when they took it. It became effective and harmed my clients retroactively. It took away something they had earned prior to July 1, 2014. And just because the legislature chooses not to revisit that issue later doesn't change the lack of notice and opportunity that was exercised in their decision-making in 2014. I have no further rebuttal other than...
How do you respond to Mr. Carswell's assessment of Atkins that although it spoke about legislative defects, it didn't establish the defect rule that you want to establish, that defect means something more than their procedures, that it means that there's a due process overlay that makes it defective. You understand what I'm saying? There's nothing, I haven't heard you say there was anything done here that violated legislative rules or violated Kansas law or Kansas Constitution on the operation of the legislature. The problem is due process rights. And so how do you get that overlay onto that statement from Atkins when you have bimetallic and all the other federal law that says the legislative process is enough, no hearings required?
Well, I think in bimetallic, there's no due process issue raised, for one. Secondly, we're not claiming that the legislature didn't follow its own rules here. It's just that the rules themselves, as they operated in this case, failed to provide the minimum due process required in a taking of property.
I understand your argument. What I don't understand is how you inject that due process requirement into Atkins' statement.
Well, I think the defect
says absence legislative defect, and interpret that to mean something else that involves due process.
Well, if you're defining defect as it must be a failure for the legislature to follow its own rules, then I don't see a defect.
Okay.
I mean, I might not like what they're doing, but I don't see a defect. But that's not my point. My point is...
Well, I understand your point,
okay.
but I'm trying to get your interpretation of Atkins.
I mean, they do a lot of things that I don't like, and I think don't meet my standard of common sense. But it's their rules. With respect to Justice Stiegel's comment about speeding, not that he's a speeder, but in his hypothetical example, the right to speed is not a guaranteed life, liberty, or property interest. That's just something that is statutory, and you don't have a right to a notice about that. You might be unhappy about it and want to go complain, but that's a statutory right in a purest sense. My life, my liberty, my property, that's different. That's property. That requires more than just middle of the night following a set of rules, but that don't offer me notice and opportunity to respond. So, in all due respect, I think they can keep you from driving faster.
Do we have any further questions? Thank you, counsel.
Thank you.
Thank all counsel for your arguments this morning. Court will take this matter under advisement. Because I understand our visitors will probably leave the courtroom at this time, the court will now stand in recess for 15 minutes.
The Honorable Justices of the Supreme Court. Hear ye, hear ye, hear ye. This court has now sitting.
Thank you. Please be seated. Now call the second case on this morning's docket, case number 106741, State of Kansas v. Thomas E. Jenkins.
Gerald E. Wells from Lawrence, representing Mr. Jenkins, the appellant, and Chief Justice, I would ask for 3 minutes rebuttal.
3 minutes is granted.
Thank you. This is a criminal case on appeal from a first-degree murder conviction, along with an aggravated burglary conviction and a theft conviction of Mr. Jenkins. There are 3 issues today that we filed on appeal. One concerns was there sufficient evidence for a reasonable jury to convict Mr. Jenkins. Secondly, did the district court err by not ordering a new trial for juror misconduct? And thirdly, on a post-trial proceeding, did the court err in finding Mr. Jenkins competent in that post-conviction under Davis? Chief Justice, I would like to concentrate and focus my argument today on the second issue, which is, was there juror misconduct? We would stand on our brief on the first and third claims in our appeal by way of not conceding, but certainly standing on our brief. There are, in this issue concerning juror misconduct, it is an unusual set of circumstances, to say the least, but we believe that the standards of review, and I say standards multiple, the case law seems to support that the standard of review for this court is whether the acts of Mr. McDonald constituted misconduct of a juror, and whether or not that misconduct substantially prejudiced Mr. Jenkins' right to a fair trial.
Isn't it a credibility? I'm confused by that. Isn't it just a credibility determination? The district court heard the testimony from the old juror and heard the testimony from the assistant county attorney and made some decisions, and so now we just look at it as whether there was substantial competent evidence, I suppose, to support it, and then the discretion we would give the judge to make that credibility determination. We can't dial back a credibility determination from this bench.
I was quoting the Mathis case, which we used in our brief, and you may be right to one degree, but the Mathis case seems very clear that there, in the consideration of this court, whether or not, and applied to the district court, whether there was, in fact, acts that constituted misconduct. The other one I would mention to the court is if it is of a constitutional magnitude, and clearly it is because the Sixth Amendment to the U.S. Constitution is implicated, is this court willing to declare a belief that the error was harmless beyond a reasonable doubt? And that comes from the
first,
court.
don't you have to, in looking at all at the cases kind of sequentially, don't we end up with the court has to look at juror misconduct and whether there was a fundamental failure in the proceeding? That's the first step. And tell me where there's a fundamental failure here and how we should look at that.
I think the fundamental failure was not recognizing the extent to which Mr. McDonald, the juror in question, was obsessed with the assistant district attorney trying the case for the state.
At the time of the trial.
Right. At the time of trial, absolutely the time of trial.
That's where the credibility determination came in, because that's where the district attorney, the district court heard the evidence, and said he may be now sweet on the prosecutor, but he wasn't sweet on her at the time of the trial.
Well,
and that's what all the evidence indicated. Where
Well,
are you,
not-
get,
not
where are
in
you
the-
getting this obsession
Right.
that manifested itself, at least in the eyes of the prosecutor, because that's when she started receiving gifts, is when there was an interaction in the courtroom 2 years after the trial, and the jurors there for his divorce proceeding sees the prosecutor and then sparks an interest. I mean, that's basically what occurred here, isn't it?
I didn't mean to step on you.
No, that's all right. That's all right.
We would differ in that assessment, in that during the hearing, because the court had 2 hearings, and the second one was
there were two gestures made on the part of the
right, and
jurors.
which I'm not going to repeat all the gifts, etc., but clearly they were, from a reasonable standpoint, a romantic gesture in both instances. But our theory in this case is that, given the testimony, and I think it's page 31 on the transcript, the second transcript, where Mr. Bell, who was appointed by the court to represent Mr. Jenkins in the jury misconduct hearing, he indicates, Mr. McDonald, in answer to a query from Mr. Bell, Mr. Bell says, well, did you formulate, and I'm paraphrasing now, did you begin to have this personal relationship? Did you begin to think about her in a romantic way to send Valentine cards, enough to send a Valentine cards? And did that happen during the Jenkins trial? He says yes.
Well,
Counsel, that's in a sea of denials.
Pardon me?
When you read the entire transcript on that one passage you're referencing is in a sea of denials. And they're not just, no, I didn't do it during the trial, no, it didn't affect my decision in the trial. It's no, no, absolutely no, several times.
I understand. I understand what he's...
And that's, I mean, when that's the testimony, doesn't my colleague have a point? Once the trial judge evaluates that, how do we undo the trial judge's evaluation of that, what you might characterize as one conflict in that sea of denials?
Because it is our point that it was so intensive an obsession that it could not have just started the moment the trial ceased.
So it's an inference you're drawing.
I am drawing an inference,
behavior.
and it has to be somewhat subjective because of the nature of the obsession. And it is our point that if he was so obsessed, and he disregarded every order and every piece of advice that came to him particularly after the first hearing. So that has to say that this didn't start, well, I'm going to be obsessed with this young woman after the trial ends. It is our belief that this obsession started, and he admits to so much in that answer. Now, you can quibble about what that answer means to him and means to the court, but clearly he was obsessed. That's a given. And he rejected every piece of advice and went back and did the same thing again twice. So, using common sense and reason, it is our position that this started during the trial. And I think you could at least take his answer to be truthful. Now, does that affect? How does that affect?
Well, let me,
sure.
Given that, how does KSA 6441 come into play here when we talk about that it's improper to get into the mental thought processes of jurors and how they rendered a decision? How does feelings towards one of the respective counsel, or whatever feelings they are, enter into isn't that a mental thought process that enters into the decision making that's not allowed for an inquiry?
Well, it did allow for an inquiry, and the mental process was evident from the depth of his obsession with this woman.
And how did that impact how did that impact?
Well, let me back up a little bit. There was testimony that they had investigated
and this juror misconduct and spoke to, I think, 6 jurors.
Which turned up nothing.
Turned up nothing. However, if you have this mindset that you are suddenly romantically inclined towards this person and obsessed, and that's not too strong a word here, then you deprive a criminal defendant of the opportunity to have a fair and unbiased juror, because it only takes one. And he was deprived of that right by this person's obsession with, as you say, whoever. But in this instance...
And you know, you've been in the trenches of criminal cases. You understand this. What if there's a juror that ends up just despising one of the advocates? Is the same thing true with that?
Well...
And doesn't believe a word that comes out of that attorney's mouth.
That happens, absolutely happens.
And
but
we don't allow an inquiry into that thought process and how that impacted.
But that it's not raised in a post-hearing situation where this court ordered a remand not once but twice on that very subject matter. So it depends in the context of what's happened. Because this court must have felt that there might be something there that was critical and potentially biased on the part of that juror.
Counsel, what is this may have been referred to earlier, what is our standard for reviewing the district judge's determination that there was no juror misconduct?
Well, if there's no misconduct, I don't think it triggers the rest of the standard. I mean,
isn't that what the judge found? That there was no misconduct?
He did find that there was no misconduct. We think he was in error in doing that.
I understand that. I'm asking you to tell us what standard we use to review the district judge's determination that there was no misconduct. Is that a question of the amount of evidence?
No,
or something else?
It is the court's decision based on discretion, in my view. Now, that has been amended somewhat if I read the Mathis case correctly. But, I mean, that's what it boils down to.
So you're arguing that the judge abused his discretion in this determination? I think
that's correct. Because he didn't find an act of misconduct when clearly the facts, as we see it, indicated that.
As you know, we use 3 prongs to define abuse of discretion. Are you saying that this is outside the decision that a reasonable person, that no other reasonable person would make the same decision, or are you saying that there are not facts that support the decision?
I think no reasonable person would make the same decision on whether or not this was so obsessive that it was a violation of the Sixth Amendment. Now, quite frankly, when I researched this, I came up with the Mathis case, and that's a little bit of a twist on the discretionary power of the court. But there it was. There was Mathis, and also because it involves or implicates the Constitution, Sixth Amendment in particular, it was also a twist on the standard of review for this court. But I would agree that the court has discretion to decide that. They just erred. Judge Helmer just erred in that discretion. Because of the depth of obsession, the timing of it, and the fact that he was a juror on a case that the ADA prosecuted. And he admitted as much, although I take your point, Justice, that in the context of the entire hearing.
Aside from that one exchange, which is a little ambiguous in and of itself, he was emphatic. He wasn't just saying, no, it didn't affect, no, it didn't happen then. He was emphatic. He said no, absolutely no, more than once.
But he also disregarded every other order that came his way.
In that moment. But when they were inquiring about the moment that matters, which is the trial of Mr. Jenkins, he was emphatic that he had no feelings for the prosecution.
But I think you can question that by the fact
Sure,
that
you can question it, but the district judge made a judgment with him sitting in front of him.
he did.
That's what I was
He
trying
did.
to get at.
Yes.
Any further questions? Thank you, counsel.
Thank you.
Thank you. May it please the court, Ellen Mitchell, Saline County Attorney, appearing on behalf of the state of Kansas, the appellee in this case. This was a 2009 homicide case, and it didn't go to trial until March of 2011. At that time, the assistant county attorney and the juror in question had never met before, didn't know each other, didn't know of each other. After the jury's verdict was rendered, the prosecutor and myself met with some of the jurors afterwards, as we normally do. They had a few questions, wanted to inquire about, and we did meet briefly with them in a waiting room after the verdict was rendered. There was no other contact or conversation between the assistant prosecutor and this juror until the fall of 2011. We were trying another homicide case. She stepped out in the hallway for a moment. She saw this juror sitting there on a bench. She said hello. He said, "I'm getting divorced. I'm waiting for my divorce attorney." We were in the middle of another trial, and she proceeded on. 3 months after that, she received at the office cards and candy, a poinsettia, and a note about whether or not she wanted to attend a New Year's Eve dance in which a popular local band was playing. She wrote him a note indicating to him that she could not accept those gifts, thanking him, but she could not accept those gifts. And the investigator in my office returned those gifts. He was not home. He just placed them on the front porch, and we don't know what happened to them after that. And we just took them to the address that we had from the juror list, which may or may not have been his address after he was divorced. Nothing happened again until Valentine's Day, and he just called and left a message with the receptionist that he wanted her to have a happy Valentine's Day. And the final contact was a year later, in February of 2013, when a local high school fundraiser where they come and sing you Happy Valentine's Day and provide you with a rose and some chocolate, did so in the front lobby of our office. As the questions from the court have indicated, the state contends that he was entitled to a hearing, there was an investigation, and while certainly we're not supposed to inquire into the mindsets of the jury, we felt it was important that the defendant had a fair trial and permitted it to happen and didn't object to it happening. And Mr. Sheehan conducted an investigation through an investigator as well as himself. And then after the second round, I believe it was Mr. Bell, Mr. Sheehan was removed from the case and another attorney was appointed, and an investigation was conducted as well, and they both rendered the same results. None of the other jurors that were interviewed believed that it had any impact on the case. It is the state's contention that the defendant received a fair trial, that there is no evidence to support that the juror in this case became infatuated with the prosecutor, one of the prosecutors in the case, and that after the judge held the hearing, heard from counsel, and heard from the juror in question, it found that the defendant had received a proper trial, a fair trial, and that there was no juror misconduct. And we believe that his finding is supported by the evidence, by the testimony given, that it's not based on an error of fact or an error of law, and it was certainly a finding that could have been made by other reasonable persons who were sitting to hear this case. We ask that you affirm the conviction and the court's subsequent rulings in this case.
Counsel, were you going to stand on your brief for the other two issues then? Or you care to address them?
I could briefly address them, in just that in the first argument, defense counsel the appellant's counsel does not make any specific argument as to what specific element of the defenses was not met. The state does admit that there is certainly a lot of circumstantial evidence in this case, but it certainly does support the jury's verdict. The police left that apartment complex at 2:35 in the morning, and about we have someone who places the defendant there at about 3 in the morning. The defendant denied even knowing where that street was. The defendant pointed out that the upper apartment complex door was open. That's Ben Friedman's apartment. His sliding glass door was open. And by 4:45, Ben Friedman was awake and discovered his apartment had been burglarized, which led to the discovery of the defendant's body in the lower apartment. It's a fourplex. A lot of the evidence came from the girlfriends of the defendants in this case, including the defendant's own girlfriend/wife. She indicated that the defendant had asked her and her friend to make up an alibi for them, and they initially did so, although subsequently she came forward in the fall, about in September, and told the police what she knew about the event, that she had been frightened, and advised that the defendant had been physically abusive to her to prevent her from coming to the police, and had even locked her in a room with her child and had his friends come over, and she told what she knew about the homicide. And he said, if I get arrested for this, CD, my friend whose street name is CD, will be the one that will administer the punishment to you for telling. The defendant and the co-defendants were together at Miss Jenkins' home, at Miss Yannick's home, and at Miss Wellman's, their 3 girlfriends' home, early in the morning, putting them together. But probably the strongest evidence is that the day before the murder, the defendant, Mr. McSwain and Mr. Bates, are at the defendant's home. The defendant needed money. He had lost his job. Bates said, I know where you can hit a lick. It's over on Johnstown. The occupants will be out of town at a concert. They have money and drugs in the apartment. He had just bought drugs there just before this happened. The roommate of the deceased indicated that they'd had 10 pounds of marijuana and 17 grams of cocaine in the apartment. That day, he had left to go with a female friend for the evening. And when the police got there, there was no marijuana and no cocaine left in the residence. They were able to match the serial number from Friedman's PlayStation to one found at Willie Parker's girlfriend's house. The defendant called his wife, who was parked out in the county with another man, Hassan Williford. He told him that he was sitting outside the place. They were about to go in. He'd call her back. He called back 15 or 20 minutes later. He said that some things had kicked off, but he took care of the situation. And would ask you to recall that, remember, no one was supposed to be in there, and he got a surprise when they kicked open the door. In addition, his wife said the defendant had a gun that he always carried on his person until this happened, and then he stored it in Bates' car. The defendant had been an employee at Russell Stover's, where he had been assigned some work boots that were black and yellow, Service SCRV US brand. The police observed that the door had been kicked into the victim's apartment. They used a piece of equipment to enhance the photograph of the door, and they saw the footprint. There were parts of the word service on the door left in the dust. Miss Jenkins also testified that her husband owned a pair of boots like that from his employment, and that a couple of days after this, they went out into a rural area of Saline County and attempted to burn the boots and left them there. At the time of this trial, the boots had not been located, though. And in addition, the defendant almost gives us a confession in the song lyrics where he describes what happens. He references snitching, and it was part of the record that the victim in this case had been a victim in an earlier case, and he had met with the police and given information. And in fact, the police, my office had just served a subpoena on Almac the day before, the Friday afternoon before he was murdered, early Saturday morning. So the state believes that there was sufficient evidence on all of the cases to tie him and his co-defendants, Willie Parker and Justin Letourneau and Justin Graham. And as the court knows, Justin Letourneau was subsequently murdered, and there was evidence in the Jenkins trial that happened, that Willie Parker later committed the murder of Justin Letourneau, who was involved in this.
And what,
There was
explain, go ahead,
ballistic,
Jess.
there was some kind of ballistics evidence, wasn't there?
There
on the
was.
Used in that murder and the gun used to kill Mac.
That's correct. And there was a shell casing. It appeared from the evidence that the door had been kicked open, and Al Mack was in a chair, and as he started to rise, it's a very small apartment, that he was shot. And there was a shell casing right there at the entryway of the door. And we took that shell casing and a shell casing found in the car where Willie Parker killed Justin Letourneau, and matched those, and they came from the same gun, which was another tie-in. Otherwise, the information about Letourneau's murder may not have been part of Jenkins' case, but it was. And it was also a reason I think this court addressed in the Willie Parker's case.
Was that gun found or was not found?
It was not. It was in a it was not. It was Willie Parker. It had been disposed of prior to him taking Letourneau to the hospital. And finally, just on the other issue, just briefly, Thomas Jenkins had written a note, and at the Saline County Sheriff's Office at the jail, they read the outgoing mail as part of their security procedures. And they happened to open or review a letter that the defendant wrote. And it had some things that led them to believe that he might be suicidal. He's talking about a poem that he wanted read and what people should wear for the funeral and that sort of thing. And so out of an abundance of caution, Nurse Beth at the jail contacted defense counsel and said, we have this concern. We've got your client in suicide watch. He should be evaluated. And that's what happened. And no one had observed any behavior or anything that led them to believe that the defendant had a serious mental illness. We were just concerned that he was...
well, did counsel file a motion? His counsel filed a motion. The court granted that motion.
It did.
Ordered a mental health evaluation. And then it just goes away.
And
nothing happens.
Unfortunately, we failed to make a record and come back before the court after that happened. And instead, we just kept moving and didn't make a formal finding on the record. And so that's why we had agreed, did not contest when the court remanded this back. This case is different than other cases might be. And this is not a case where the defendant was actively hallucinating or saying or doing unusual or unique or bizarre things in the courtroom. We were just acting because based on the recommendation of the sheriff's office that they believed he might be suicidal. The defendant denied being suicidal, and in fact wasn't happy that he was in suicide watch for several days. And as soon as they received the letter from the mental health center, he was released, although he was kept in the booking area. He was giving his clothing and things back, but he was kept in the booking area for a little while longer. And so under the facts of this case, because we had the evaluation and because we were really just acting out of an abundance of caution to make sure that the defendant was fine and able to assist in his defense and not suicidal, we were able to have a retrospective competency hearing. And
well, the key to is the four factors that the court pointed out, but it's you had the evaluator present, you had her evaluation, you had the nurse at the jail, you had defendant's trial counsel, the prosecutor, and the judge who presided over the case.
That's correct.
Every one of those were present and testified in the retrospective hearing. Isn't that right?
That's correct. And so under the facts of this case, we believe that it was appropriate in
well, that it's certainly feasible to have a retrospective hearing given the parties that were present.
It was. And everyone's testimony was generally the same, that they had not observed or seen, or he had not done anything in particular. It was just based on that note. And he even denied that it was a suicide note or that he meant anything by it. He said it had to do with something else, some other kids that had vandalized a cemetery. But in any event, we just did it to be cautious. The nurse was concerned. Her concern was addressed. He was placed back in the general population, and we proceeded, although we should have proceeded on the record by making a formal finding. But Judge Thompson did that later, and Judge Helmer was able to testify, as well as my assistant and the jail staff. So we'd ask that you affirm the decisions that Judge Thompson rendered on the competency issue as well.
Any more questions? Thank you,
Thank
counsel.
you.
Chief Justice will waive rebuttal.
Would you mind standing at the lectern so people watching online can see who's saying that, please?
I keep forgetting that. We'll waive the 3-minute rebuttal that we originally requested, Chief Justice.
Thank you. Anybody have any questions? Thank you. Thank you both for your arguments this morning. The court will take this matter under advisement. Now call the third case on this morning's docket, case number 108625, State of Kansas v. Dana L. Chandler. Is Ms. Schlimmer in the courtroom?
Justice, she was here earlier.
I think she's coming.
May it please the court, my name is Stacy Schlimmer and I represent the appellant Dana Chandler in this case. May I reserve 4 minutes for rebuttal, please?
Counsel, before you proceed, according to our assistant clerk of the Supreme Court this morning, you missed the, what I call the roll call before any arguments were held on our docket.
Yes, and I apologize, Your Honor. There is other counsel, Adam Stolte, on this case as well. He was intending to be here at 8:30 this morning, and he actually has a very bad case of the flu and is not here.
So he contacted you on short notice to ask you to fill in for him, is that right?
No, I was going to argue today. However, he was going to be here at 8:30 for roll call.
Okay. Well, under our rules, you need to request our permission to proceed because you missed the earlier event. So is that what you're asking us to do at this time?
Judge, yes, I would ask the court's permission and forgiveness for not being here at 8:30.
Okay, and I'll follow up by saying when I called the case, you were not in the courtroom several minutes ago. Can you explain to this court why you were not?
Judge, I apologize. I was in the attorney conference room, wrapping up my things, watching it live, thinking that rebuttal would occur, and I was going to come in, and when there was no rebuttal, I grabbed my things as quickly as I could.
All right, and you've requested 4 minutes for rebuttal for your argument?
Yes, Your Honor.
All right, you may proceed.
Thank you. As this court is probably aware, this criminal case was before this court a year ago. It was sent back for additional briefing on some issues. This case is a criminal case that involves Miss Chandler in that she was arrested almost a decade after the murders of Karen Harkness and Mike Sisko. Although Miss Chandler was originally spoken with by law enforcement and there was no new evidence against her, she was charged and arrested in basically a medium storm, which involved the then District Attorney Chad Taylor and Chief Deputy Assistant Attorney Jackie Spradling. The case is based on circumstantial evidence. There is no direct evidence that links Ms. Chandler to the murders. A jury convicted Ms. Chandler for the murders, but not on just the circumstantial evidence, but on the prosecutorial error or misconduct, however the court views the standard of a review, and that launched basically a full-blown attack on Ms. Chandler's character. So I'd like to start there with the opening statement of Ms. Spradling. In opening statement, Ms. Spradling referred to a report by Dr. Spiradiglosi.
Was that report part of the state's case, and was it given to the defense prior to the trial?
Your Honor, based on the review of the file, it was provided to the defense. However, there was no notice, not that the state is required to give notice exactly of which particular witnesses it would be calling. There was no notice in the form of a 6455 motion, which there was filings prior.
Well, let me understand this. So you had the report, or counsel had the report prior to trial, and wouldn't that afford an opportunity for at least a motion in limine to talk about the contents of the report, what can be talked about, what can't, and address some of the concerns you're just, I think, getting ready to address, but at least minimally the 6455.
I would agree with you, but that being said, I don't think that's the focus here. I think the focus is on whether the state had a good faith belief that based on what was contained in that report.
If you were given the report and you had this opportunity, what prevents at least the state in opening statement from referring to it? We anticipate this is going to be evidence in the case, and here's what it says.
I don't believe that it was a good faith belief that this evidence would be presented or would be able to get in at trial. I think when you look at what the statements were made regarding the doctor, the nature of the statements were so egregious that it's hard to believe that any seasoned prosecutor would think that that kind of character evidence would be able to get in at trial. And what made matters worse in this case was the state then called the doctor to the stand. So after the jury heard what the doctor's opinion purported to be, that is when defense counsel did object at the time, and the judge did not let it in because of the 6455 and the character evidence. And the judge specifically said, this was not the contents of a 6455 motion. If the prosecutor had intended to bring that doctor's testimony in, they had filed a motion that listed 8 different specific instances of prior bad acts. That was something that could have been addressed with the court, but it wasn't. And so the opening statement, it has to be made in good faith. The other thing is nothing would have prevented the prosecutor from referring to the report and encouraging the doctor to listen to what the doctor's opinion would be. And that is what you're going to find is motive to this case, or that is where you're going to find information as to the character of Ms. Chandler. But the prosecutor didn't do that. The prosecutor called her narcissistic. She said she was of high intelligence, that she had difficulty controlling her emotions. So what we have is, as an attorney in jury selection, what you do is you work on getting out all those biases of jurors. Yet in the very opening statement of the prosecutor, it's hard to unring the bell given the nature of what was said by the prosecutor in those opening statements. Not only did the prosecutor refer to the doctor's statements in opening, then later, when the divorce file was entered, the prosecutor went and told the court, we took out Dr. Spiradiglogi's report. However, the documents inside the divorce file referred to the doctor doing an examination. So that added additional weight to what they had already heard in opening statement. there were, I believe, 2 separate references. One was in the decree itself, where it said that the court was going to adopt the findings of Dr. Spiraziglo. I'm just going to call him the doctor right now. So the one was the decree, and then the other one was the actual order, where the court ordered that there be an evaluation done by the doctor. Then, to top it off, in closing arguments, the prosecutor then refers to Ms. Chandler being of high intelligence and that she thinks that she is smarter than the law enforcement, and basically that she is smarter than the jury. The problem with that is, and I understand that prosecutors can make reasonable inferences, there was no testimony whatsoever regarding the intelligence of Ms. Chandler other than the employer she worked with, who basically said that he thought she was above average intelligence. But if you look back to the opening statement, and it is on page 6 of our supplemental brief, the prosecutor told the jury that the purpose was to determine child custody, but that testing revealed that the defendant has a high average abstract intelligence, meaning she's smart. Also that she's attempted to minimize her problem and had little psychological insight. It's hard not to infer that the prosecutor's statements in closing argument regarding her intelligence went back to the report of the doctor because there was no other evidence that came in. So we have statements that are made in opening that do not appear to be in good faith. In many cases, yes, you may say, as long as it's a good faith that the prosecutor says that, there's just too many other things going on. One involves the protection from abuse. And
Before you get there, I want to stick on what you just talked about. In the closing argument, the prosecutor made the statement that the defendant was highly intelligent, and that was sort of the precursor to outsmarting you and the police and all that. But I'm focusing on the highly intelligent phrase. There was testimony from one witness that she was above average in intelligence, which I don't think equals that. But does the doctor's report, the part you just quoted, is that enough to justify, since it got into evidence, regardless of whether it should or shouldn't have been, is that enough to justify the prosecutor's statement in closing argument that the defendant was highly intelligent?
No, and I'm sorry, maybe I wasn't clear. What got into evidence wasn't the report itself or any of the recommendations were not in evidence. But what was in evidence was the decree that stated that the court was going to adopt the findings and go with the evaluation, the child custody evaluator.
I didn't have that part in my notes about the report. So just to confirm, the only thing we have to in your view, to justify the prosecutor's characterization of the defendant as being highly intelligent is that one witness who said above average.
Yes, and I would contend that that's the state's view as well, because in their brief, their response was that because this one witness said probably above average, that was the support that was given for that. The next subject I want to touch on briefly is the protection from abuse. We didn't spend a lot of time supplementing that because it was outlined in the original brief. But what we did do is comb through the divorce file to say, hey, what do we really have here, to see if there was anything that an order could have been. It's almost 1,200 pages of a divorce file, and there's a lot in there. There are only 2 items that even mention staying away from as far as a restraining, let me back up here. There are 2 things that the state argues you could construe a protection order from. The first one is an interlocutory order. Mike Cisco filed for divorce on March 3rd of 2009, I believe it was, and I'll check real quick. March 5th are these interlocutory orders. Interlocutory orders are the orders that a divorce judge, they can do temporary orders restraining people from bothering each other. They can say, don't dispose of your assets. They can put child support in that. That is exactly what this was. It was a temporary ex parte order, meaning Ms. Chandler was never even present when it was signed off on. This is something that is not uncommon in a divorce case for a party to ask for ex parte orders. So the order that was signed off was this ex parte temporary order had a list of things. One of them was the parties shouldn't restrain each other. As the court knows, a protection from abuse first is a separate case from a divorce case. You file it, it's a separate action. When that is filed, then there is a certain petition and there's a certain order that is granted. So the protection from, or the interlocutory order that was issued in no way, shape, or form was any type of restraining order. And in fact, I don't think that's what Ms. Spradling was referring to when she was talking about the protection from abuse order that she said Mr. Cisco got.
Did the no contact then get adopted after the case was ongoing? That's typically what happens. You're right. Ex parte orders are filed initially to kind of get things set, and then there's a hearing that then determines the parameters of the proceeding, and part of that is taking care of these ex parte orders. What happened? Was there anything about no contact at that point?
Based on my review of the divorce file, it would have been contained in a settlement agreement or a decree likely. I do a lot of defensive work, but I've done my share of family law. I did not see in the file anything that contained a carryover of these ex parte orders when it came to the don't dispose of your property or don't bother each other. And that was the March 3rd. It was 1997. The divorce was filed, and the 5th is when this order was signed.
Before you're out of time, but I want to talk about sufficiency of the evidence.
Yes.
The state cites two cases to argue for sufficiency. One is the Murray case, where the guy's got the cut on the hands, and I kind of don't care about that one. But the Flynn case is causing me some trouble, because it seems like there's not much here, but seems like there's more than there was in Flynn. What do you think?
In this case, I think the sufficiency of the evidence, it carries over to the prosecutorial error or misconduct, in that the sufficiency of the evidence alone, I would argue no, it wasn't enough. But I know that there are cases that...
But if the measuring stick is Flynn, and that's what I've got to wrestle with that in the analysis that I'm doing here. If that's the measuring stick, does it get above that line, or is it still below that line?
I would say that it does not hit the measuring stick of Flynn when you start to filter out what the actual evidence, and that's where I'm having a hard time, because there is a lot of evidence that was purported, but then was determined that it didn't factor out. For example, the gas, how she supposedly tracked up to Nebraska, that never got in. So based on what actual evidence got in, I would argue that no.
Well, they've got the woman in Wakini that thinks she saw a black Mitsubishi Eclipse, which is the defendant's car. So if you look at this in the light most favorable to the state, which is our standard of review for sufficiency, that potentially gets her into the state of Kansas, at least as far as Wakini. Now that's about the only thing that gets her in the state of Kansas, but if you get her there, and then you've got strong motive evidence in this case. You've got evidence of obsession, inconsistent statements made by the defendant during the time gap that we're talking about. And then you've got the Flynn case over here. It seems like I'm having trouble saying it's insufficient evidence.
I think if you look at the fact that, at the case as a whole, and the fact that there was DNA traced to the scene that did not match Dana Chandler, that's something else that you consider when you're looking at this. That's the real physical evidence we have in this case. The fact that we do have another party that the defense counseled regarding their motive. And I believe that was the ex-husband of Karen Harkness in this case, and that they didn't do a follow-up on that. I think the mere fact that someone is in Kansas, that kind of opens the door. Now, granted, she came. If we believe that this is the Miss Chandler's car that the gas station attendant saw, and that she was coming from another area, that gives you a little bit difference than saying, well, she was in the state of Kansas if she had to come. I just don't think that you're going to rise to that level when you take the contradicting evidence that they talked to Miss Chandler after this happened with an attorney present. She talked to investigators. So she had already been through an examination with them, and and the fact that they do have DNA evidence that's linked to the casing in this case.
But counsel, do we get to consider the contrary evidence when evaluating sufficiency? Because then we just look at the evidence in the light most favorable to the state. So don't we really disregard competing evidence?
I don't think the standard is that you disregard competing evidence.
Well, what else do we do with it? I mean, how does it factor in when we look at the evidence in the light most favorable to the state? We have to look at those pieces that support the state's case.
Well, you also, I think you have to look at the entirety, but look at through the lens of most favorable to the state. And so, for example, with the ballistics.
And most favorable to the state on the DNA at the scene would be they had somebody over, they left DNA, but it's not compelling.
It wasn't just DNA that they left over, it was actually DNA on the ballistics in this case. So if you look at it in the most favorable to the state, you could say, well, there's other explanations, but I think we also have to be realistic of how we're looking at it through the in most favorable to the state. That doesn't mean that I would argue you don't disregard all the evidence. I think you have to look at it
totality
as a case as a whole to determine that.
Okay.
And I know I'm out of time unless.
Do we have any further questions? All right, thank you, counsel.
Thank you.
May it please the court, this date appears by Assistant Solicitor General Jody Lipton.
Counsel, you knew you weren't going to get past just
I was hoping to get one sentence out, but yes, Your Honor.
I want to talk about the protection from abuse order. No surprise there. When the state originally argued this case on appeal, you said that the state said that the protection from abuse order misstatement, which you now concede is error, was not error. And I'm trying to figure out how something went from black to white.
And in our brief, I think the misstatement is what we are conceding. She misspoke. I thought that she said that when she was the state was arguing the first round.
Not when you read her brief. You read her brief. No, there's no problem here. It wasn't until a lot of questions came that we finally surrendered more than anything else. But I'm trying to figure out how, from the state's position, the state of Kansas, how you went from black to white on that.
In writing my brief on these supplemental facts, I did look at the oral argument and used any concessions that I thought were made at that oral argument. As she was the trial prosecutor, I believe it was important for me to take that into consideration, which is something that I was not. That was an opinion, or that was, something that I didn't have the benefit of. And so I guess that we conceded based on the oral argument and the
Why wouldn't
questioning
you
from this
concede it
court.
based on the record on appeal? You looked at the, I mean, I don't understand how that divorce file got into, 1,200 pages got into evidence to begin with, but let's take that aside for a second. I don't see how a trained prosecutor represents that there was a protection from abuse order when there wasn't, and there clearly wasn't. And not only that, but then she said, this was an order from a judge for this woman to stay away from this defendant. And guess what? She ignored that order. And this is what the jury is hearing, and all of it's not true. And that seems to be both a really big problem for the state when the evidence is this thin, and an indication that takes prosecutorial error, now under our current case law, from just error to being misconduct, which we've said we reserve only for really serious offenses.
Sure.
Talk me down off of that.
Okay, well, the comment about the PFA, I guess where I was conceding error is if you're saying that it's a misstatement of the evidence, which I think that's clear, at least from your viewpoint, that there was no PFA, she said the words.
Isn't that your viewpoint too?
Yes, if you're considering it to be a misstatement of the evidence that she stated the words protection from abuse order, there was no document called a protection from abuse order in the divorce file, then that would be a misstatement of the evidence, as there was no piece of paper that she could point to support that. However, I think it's important to look at the record as a whole when we're talking about prosecutorial error, and even under Sherman, and know that this was not, I think it was a misstatement, and I know I keep going back to the old standard with ill will and gross and flagrant, but it was simply the title of an order. And she stated in 1998 that there was an order, which is correct, and that it was an ex parte order, just not a protection from abuse order. So she did.
If you take that viewpoint, that that's what she was talking about, then the order was directed at both of the parties, not just her, but she said it was directed at the defendant. So that's a misstatement, even if I give you the other part, right?
Yes. It was to both parties, not just to her. And then I think in combing through some of the other pieces of evidence in the divorce file, it was, I don't remember what the motion or whatever request it came from, some sort of request. So the request was from Mike. So I think that's true. The request to get this order.
She didn't talk about a request from Mike. I mean, she said she had an order that the judge agreed that that defendant should stay away from that victim, and that she also ignored it.
Right.
That seemed to be a pretty big deal.
And if I can point the court to, Mike got a protection from abuse Mike got a protection from abuse, a court order. If she would have said, Mike got an ex parte order, a court order. There was an ex parte order.
Just fill in the blank, directed
Sure.
at both parties. It doesn't have nearly the impact, does it, as the misstatement?
I don't know. I don't know that I can agree with that. I don't know if the emphasis on this piece of evidence that the court places on it is the same as what the state
It gave
places
the
on it.
imprimatur of the court to her dangerousness. That's what's so unacceptable about it. It implied, if it didn't outright state, that he went to court to obtain an order because she was dangerous, and that what he got was exactly what he asked for, and then she violated it. What he got were some temporary orders that are routine in domestic cases when they're opened, and he happened to be the filing party, so he was the one asking for it, and he got an order that restrained both him and her, which implies nothing about either of their dangerousness, just says when parties are in the process of getting divorces, they should leave one another unmolested. Isn't that true? Isn't that the state of affairs here?
It is, but can I make an argument that what was the evidence presented about the PFA order? How, of course there's an inference of dangerousness if you believe that the jury believes, wow, protection from abuse order, that must mean, or if they knew that that was the same as a restraining order.
Even
yes.
just that the order was directed at her alone.
Sure.
Okay.
But there was no evidence.
Explain to me why this doesn't matter.
On what a protection from abuse order means. That wasn't, at least in my view, the only evidence that about the protection from abuse order was what we've already gone over with. The detective said, was there one issued? Yes. Was it issued against the defendant? Yes, in 1998 or 7 or whatever she said.
That's not what the detective said. The detective said, well, and then he came back and took it back.
Yes, and I didn't get there.
Okay,
Agreed.
okay.
Agreed. He took it back. But there was no harping on, does this mean that she's dangerous? What's the standard that you have to apply a protection from abuse order? What did she do what was in that motion for a protection from abuse order? What were specific instances of her obsessive,
It is
behavior?
called a protection from abuse order.
Yes.
Which seems to me pretty explicit that there's some dangerousness implied.
Yes, and we're taking this out of page 24 from a closing argument where there was nothing in the trial to tell the jury the importance of that.
Well, let's put it in context. Let's put it in context from page 24. The first thing the prosecutor says here in introducing that, you said she didn't harp on it. How else do we know the defendant is guilty? Mike got a protection from abuse, a court order. He applied and said, hey, judge, please order this woman to stay away from me, and the judge agreed. And in 1998, meaning 1 year after he filed divorce, he was continuing to have problems with the defendant not leaving him alone. He got a court order saying she has to stay away. The protection from abuse order did not stop the defendant, though. She broke into Mike's home through a window and looked around. Gosh, when you've got a limited amount of time in a closing argument, that's got to be prime time, if not harping.
And I would have to respectfully disagree. And she did begin many of the paragraphs, and I didn't go through and count, how else do we know the defendant is guilty? That was a common thing that she said throughout the entire closing argument, saying, how else do we know the defendant is guilty? X piece of circumstantial evidence.
If you're going to say to the jury, how do we know he's guilty? I mean, shouldn't you be pretty darn sure that what you say next is true?
There is a duty to know what evidence came in, yes. But this was not the only, I guess my point to that is, this wasn't the only time that she told the jury, how else, and the only reason we know he's guilty, this protection from abuse order. It was repeated throughout her closing argument to link each piece of circumstantial evidence.
Counsel, you mentioned there was nothing in the record that gave the jury evidence as to what this particular order was. Is that true with respect to Mike's alleged motivation for seeking the order? Because I read into this statement by the prosecutor that he was afraid of her. This is her words. He applied, I mean, we've already read this, but I'll read it again. He applied and said, hey, judge, please order this woman to stay away from me. And the judge agreed. Is there anything in the record that would support that inference of Mike's motivation?
Well,
is there anything that was even close to him saying, please order this woman to stay away from me?
well, if the prosecutor was referring, there was also a request for a restraining order. So that's where it gets a little tricky too, is there was a request in 1998 for a restraining order, which the record doesn't show whether that was granted or not granted.
So that's also a statement of facts that are not in evidence.
I don't know if that came in with his attorney, Gordon Rock, in that testimony. I didn't go back and specifically look at that for today, but there could have been testimony on, and didn't Mike request a restraining order in 1998 or something to that effect, but
Well, before we leave this, I don't know whether we were going to leave this or not, but my question is just based on this paragraph that we're talking about, how can we say that that's harmless? You've conceded error, so we're already in harmlessness.
Well, can I address prejudice as well?
Well, that's I mean, can you
Yeah,
satisfy
okay,
the Chapman
that's
test? Right.
Yeah.
How
yes,
can you
sorry.
say it is harmless? That was his
If I can get to the second problem, yes. And I've got it somewhere here. I've got a couple of points, and I tried to put them, I think, in the order that was most persuasive for this court. One, the district court has a duty to prevent prosecutorial error on its own. It's got an independent duty to do so. And when this statement was made during closing argument, the district court did not say, counsel, please approach. You've made a misstatement of fact. I believe this is a grave error. You need to correct that. You know, the court has a duty to do it on its own. This got by the district court. This got by, to a lesser degree, defense counsel, because I know this court has said they don't have
Obligation to object. To
yes, or an
prosecutorial.
incentive to do so because they can raise it later, and certainly it's not required. But more than that, the district court didn't say anything. So I think that this court can weigh heavily on that, in that it got past the district court didn't even notice.
But all errors by definition got past district courts. Every time we do anything that reverses the district court, something got by the district court.
Sure.
You can't really mean that, can you?
Well,
That's
I
what
think-
appeals are for.
I think it's a factor to consider, because certainly if the district court would have stopped and did that, and maybe
Then nobody would be talking about this.
well, maybe the prosecutor would have went on and said something different anyway. I mean, went against that court order, but I see your point.
Yeah, I mean, it got past the district court is not very persuasive. I hope you started at the bottom.
Well,
of your
I thought it
list.
was particularly persuasive.
Okay, we have a disagreement on that point.
Yes.
What's next?
Next is the no objection by defense counsel. And I think that's important in this case too, when defense counsel did object on a separate misstatement of fact. Defense counsel did, I believe it was at the break after the first initial closing argument, bring to the court's attention, look, the prosecutor is saying something that Jeff Bailey said, or something that the defendant said to Jeff Bailey, and that's wrong. And we need to check that, and that is a misstatement of fact. And the district court was very intent on going back and reading the transcript, finding that to see if it was a misstatement of fact. The court reporter was not able to pull that up, so she looked at her own notes. I mean, they had a long discussion about this misstatement of fact, and the prosecutor's attitude was, I don't want to mislead anybody. I want to fix this.
Well,
So I think
all
you can
that
use
might be relevant if we were trying to figure out whether this was error, whether it actually was a misstatement of fact. But we're not. That's not the focus of this particular inquiry here. You've conceded error. It was a misstatement of fact. And the only question is, what impact did that have on the verdict? That's the only question.
And yes, and I agree. And I think if it had no impact on the district court, and I think if it had no impact on the defense counsel, who did object to a separate misstatement of fact, that has to go to reverse. I mean, that has to be for prejudice. If it didn't, those two people didn't see the misstatement of fact, I don't know that you can say that this had a reasonable probability, or whatever the standard is, to affect the jury.
Well, here's the standard. I know you know it, but let's get focused back on, instead of prejudice, get focused on our precise standard. You have to demonstrate to us beyond a reasonable doubt that the error complained of did not affect the outcome of the trial in light of the entire record. That is, where there is no reasonable possibility that the error contributed to the verdict. And I guess what we're saying is, if a defense counsel missed an objection, or the district court didn't sui sponte jump in, how does that fit into that calculus? How does that prove to us beyond a reasonable doubt that the error, which is already conceded, had no reasonable possibility of contributing to the verdict?
That if the two people, I would say that if the defense counsel, who knew all of the facts way better than the jury, and the district court, who has an independent duty to make sure there is no misstatement of facts, didn't catch this misstatement and didn't bring it to the attention, I would say that is an indication that the jury wouldn't have
Right,
put
the
much
jury
stock
thought it
into
was
that.
true. The jury believed it. That's I don't see it. Your argument cuts against your quest to have us find this harmless.
Well, if I can continue on my quest, I will raise another
Yeah, please
point.
do.
Well, I want to bring another point.
Yes.
I want to be mindful of our time, and I want to give you a fair shot at this. But what evidence is there when the prosecutor told the jury that the defendant, quote, drove directly up to Nebraska? After she gets to Nebraska, she turns around and goes home, heading towards Denver. That's what the state of Kansas said this woman did, and I don't find any evidence of that.
And can you clarify, was that an opening statement?
Yes.
Yeah. I believe that the prosecutor had a good faith basis to say this, and going back to what is allowed in opening statement, there's a reasonable latitude to for the state as to what they believe that the evidence is going to present. And the state was prepared to present this with Detective Boley's testimony, tried to, There was an objection, and the district court later held that.
But the question was speculative. It was, well, she could have gone north and gone to Nebraska. That's what the question was, which is just pure speculation. And anybody in law school knows you don't go there. So I don't see how that is a good faith belief to be this certain that this is what you're going to tell. You're telling the jury, this is what the evidence shows. Not that she could have turned left, she could have turned right. I mean,
right.
You could just as easily say she drove to Oklahoma.
Sure.
But she didn't say that. And she didn't even say, well, she might have. You know, there's an indication in the evidence. She said she drove to Nebraska. And then when she gets to Nebraska, she fills up and then heads to Denver. There's no evidence that supports that statement. And I don't see why that's not, again, over the line of error and into misconduct land.
Well, and I think maybe that would come with the answer from Detective Oley as well, that was not allowed. I think that there was a good faith basis for the question, because I believe it was an investigative conclusion based on the gas, based on the 5-gallon gas cans, and when she had filled up, that going north would have taken her quickly out of the state rather than going down to Oklahoma or east or west. And that was the fastest way she could have gotten out without filling up. So I think that there was evidence in the route that she took, the fact that she stopped in Waukene and then had to get out of the state quickly without filling up.
Would have been shorter to go straight to Missouri. I mean, it's hard to believe there's a good faith basis that you're going to prove beyond a reasonable doubt your case when you think what you're going to do is ask a detective whether it's possible to go north from Topeka. I mean, I know it's possible to go north from Topeka. You don't have to ask a detective. But it's
Right.
also possible to go east or south. And I mean, this kind of stuff just jumps off the page. I'm harping enough. So
Well, and I think it was based on some investigative conclusion made by the detective as to why it was relevant to ask him those questions. Back to prejudice, I'll jump to the jury instructions and go with this longstanding law that the jury is to presume to have followed the jury instructions. And in jury instruction 3, as in most trials, it states that statements, arguments, and remarks of counsel are not evidence intended to help you in understanding and applying the law. Statements that are unsupported by the evidence should be disregarded. And this court regularly relies on that as a part of the prejudice analysis. Also, jury instruction 5 states to consider and weigh everything admitted in evidence and disregard any testimony or exhibit which was not admitted. And I believe that was a preliminary instruction as well. Something similar to instruction number 5.
Does it make a difference when we apply that we're talking about a 1,200-page exhibit? I mean, do we really realistically expect that a jury is going to page through 1,200 pages to verify that the comment the prosecutor made about an order in that file is there?
The way I'll answer that is just that we presume that they followed the instructions. Here I know that we had a very large number of exhibits, I think over 1,000, and a lot of 86 witnesses and a lot of testimony, and a short amount of time to the verdict. So I guess I would just fall back on they're presumed to have followed the instructions. And even if they didn't go through that exhibit, there was at least the testimony from the detective who said there was an order and then there wasn't an order. And then defense counsel said, oh, we'll get back to that, and they never did. So there could have been a discussion by the jury about that testimony. We just don't know.
One of the other problems, talk me down off of this point. The state's case was like a fire hose. It was like a data dump. You put all these witnesses on, all these documents, and you didn't really do anything with any of them. And most of the witnesses are talking about stuff that is cumulative. I mean, it was just a data dump of stuff, which I think makes the closing arguments of the attorneys far more important when the jury's just inundated with a bunch of stuff. You put 12 hours of jailhouse phone calls in it and then didn't play any of them in the entire trial. You played a couple snippets in the closing argument. I mean, that's an example of this. So, explain to me why that doesn't enhance the importance of the closing argument by the counsel when the jury has sat here and heard just so much stuff and then trying to make sense of it.
I think if we look at if the PFA was the only evidence of motive, I think it becomes extremely important. Or if this protection from abuse order was the only thing that they had establishing, we didn't have any inconsistent statements. We didn't have any jail phone calls that infer, about the DNA and about the state's witnesses from Waukegan, Kansas. If we don't have those witnesses in Waukegan, I think it makes a much bigger deal. I think there's more circumstantial evidence here to motive that makes the PFA comment less important. And that's what I would turn to for all of the other evidence that was about motive by the children, all of the specific instances about her during the divorce case using the child custody to follow and stalk and harass. And if there was none of that, and the only thing focused on this PFA, I think that it would be a bigger misstatement.
The inferences that the prosecutor made about being highly intelligent, are those reasonable inferences based upon the admitted evidence? And explain to me why it is, and why she's smarter and outsmarted everyone.
Well, I think it is a reasonable inference based on the testimony that this court may or may not agree with on her former employer, saying that she had above average intelligence. And I think
Isn't that it? That's all you had? Yeah.
That's the only testimony we have. And it may be a reasonable inference to think if she had been interviewed and 9.5 years go by and she was not arrested, she could have thought maybe that I don't think that's an unreasonable inference to think she could have outsmarted law enforcement, just due to the nature of the time of the case.
Do we have any more questions of counsel?
Just a quick follow-up, if I may. You were going through lists, particularly on harmlessness, and I just wanted to ask if you got through your whole list.
Well, if I could mention, I've got a few more, but many of those go to it's not repeated or emphasized, it's not indifferent to a court ruling, some of the previous
pre-Sherman
factors we would look at, which we still think are relevant. I would also point to, if we're looking at the record as a whole, the prosecutor correctly stated that he made a request for a restraining order twice in opening statement. And I know that cuts both ways to think, oh, well, in opening statement, the prosecutor said it correctly 15 days before closing statement where she said it incorrectly. But I also think that the jury did hear it correctly twice, at least in opening statement. So this wasn't something that was repeatedly misstated. And I think that cuts against purposefulness, in her misstatements. So if we look at the record as a whole, it was stated correctly in opening statement. And also that this is not just a made-up piece of evidence in the sense that she's not stating that there was some sort of piece of forensic evidence there that wasn't. Or there were orders there. There was a request for a restraining order, and that's where I think it gets tricky. This isn't just something that's made up out of whole cloth the gun that we found there was no weapon. I mean, this was clearly not something that was entirely made up. And then if we look at defense counsel's closing argument, I think this cuts against prejudice as well when, addition to the jury instructions that they were told to look at the evidence that was admitted, defense counsel's closing argument said, look, don't just take the oral claims of the prosecutor and believe them. You've got to look at the evidence and make sure it's supported. Whatever they say is supported by the evidence. So it says, use your own recollection of the evidence. Don't rely on what Ms. Spradling or Mr. Taylor tell you. And I know I also said that statements of counsel are not evidence, but I think the jury did hear repeatedly from defense counsel, don't just buy what they're saying, go back and check. And if you have a duty to check the evidence and make sure what they're saying matches up with the evidence. So I think defense counsel did do a proper job in telling the jury that they have to rely on the evidence. And I would just respectfully request that this court affirm the convictions in this case.
Thank you, counsel.
Thank you.
You reserve 4 minutes for rebuttal.
I'd like to have an opportunity then to talk about, I kind of got into the orders, or what we actually found in the file. The one was the March 5th, 1997 ex parte order. It's important to note that order was never the subject of a 6455 motion, although the alleged PFA of October 1998 was part of a 6455 motion. And the reason that is important is the prosecutor's statements seem to be directed at that motion for immediate restraining order as far as getting a PFA in that October 1998. Now, what's important to look at when you're looking at the conduct of the prosecutor is kind of the whole picture. And there was a 6455 motion, and that was actually briefed by, in the last brief, and there was the list of different items that were brought up. One of the items that was brought up was including on 2 different occasions slashing automobile tires and ripping the convertible top of an automobile. This was actually, the trial court said you cannot get into this. And the state concedes this in their original brief when they talk about the 6455 evidence. They concede that judge said we couldn't get into that. The motion for immediate restraining order that was actually entered as part of the divorce file is found in volume 96, 380 to 381. When the divorce file was entered into evidence, the state proffered to the court that it had taken out Dr. Spirigolosi's report, I think it was Blair's report, 6455 evidence. If you look at the motion for immediate restraining order, the B specifically says in there, destroying personal property of petitioner's acquaintances, including on 2 different occasions, slashing automobile tires and ripping the convertible top off an automobile. So this should have never even been before the jury, because the judge had already determined that it wasn't going to be allowed under 6455. But it was entered as part of the divorce case. It's this motion that I believe, based on the context of what the prosecutor was saying, was the basis for Ms. Spradling saying in 1998 he got an order. There is no order in file. This motion for immediate restraining order was the subject of the 6455 motion that the state filed. And in fact, if you look at what the 6455 motion outlines, it outlines the specific things that Ms. Spradling wanted to bring into evidence from the respondent's motion for restraining order. If there had been an order, that would have been brought up at the 6455 motion, because the 6455, the judge says, you can get that order in for evidence of her harassing him. So that was the ruling of the trial court at the 6455 motion. So had she had an order, surely they would have brought it to the court, before the court. But they didn't. Instead, what was put in evidence was a divorce file that had hundreds of pages in it that the state proffered to the court that certain things were not contained in that file. Yet, when you look at it, those things were contained. And so then you have to begin to look at the whole picture. Is it just the fact that she misstated simply this chief deputy prosecutor who is working a murder case, a cold case that's in the media, that she just happened to couldn't tell the difference between a protection from abuse order that has a different case number, wouldn't even be in the divorce file unless for some reason they entered it for some other reason, or maybe the attorney had it. The other thing that's interesting is that Ms. Spradling never questions former divorce counsel regarding the orders. That's never brought up with former divorce attorney for Mr. Sisko when he testifies. So I think there is an inference here that maybe the prosecutor believed that somewhere out there this order existed. I think in her oral argument before she said she had talked to family members. But that's not evidence. And to come back and say now, well, maybe she misstated it because there were orders in file, there's still, I don't know what orders the state is talking about. There's an interlocutory ex parte order, which does say each other can't restrain, but there is no other order that talks about restraining. There's a motion, and the motion was never heard by the judge. A motion that should have never gotten to evidence because it contained the same 6455 evidence
That had been disallowed.
that had been disallowed. And the state concedes that. If you look in their original brief, which Miss Spradling was part of, says that the judge took that out. Didn't let him get into that.
Is your point that that's an indication that we should take this case from error to misconduct? Because the evidence got in. I mean,
right.
You know, you'll have a
Right.
different day to talk about
Yes.
ineffective assistance of counsel, maybe. But is that the point you're trying to make with all this?
Yes, my position is that Sherman should be the controlling case, and I think this court just had another case that from Sedgwick County that it used the Sherman test on, even though the appellate court, Sherman hadn't been out yet. So I would proffer that we should use the Sherman case. However, I know the state in their brief had said that it wasn't quite certain which standard to use.
I don't think you maybe followed the question from my colleague. He's asking, even under Sherman, there's error and misconduct. And he was asking you whether you were offering what you just described to support the position that we should regard what happened here as misconduct under Sherman rather than mere error.
I will, with candor to the court, when I was reviewing this, I do. And the reason I want to bring this up is I did not include this in my brief because as I was reviewing the file, for court, that's when I realized, oh, this restraining order actually had this clause in. So, and the reason I'm telling the court that is because I would believe I have an ethical obligation then to bring this to the attention of the disciplinary board or something like that if you're talking about State v. Sherman. I do believe that the fact that the state proffered to the court that they took out 6455 evidence. Now what they did say is that, which was contained in handwritten notes. So I don't know if that means they only took out that 6455 evidence, but it's apparent that that is what the defense attorney was addressing was the 6455 evidence, and they did proffer to the court that was removed. This is contained in that file. So to me, yes, I believe that they knew that motion for restraining order was in there, or they should have known, and that had been decided to the judge to be inadmissible. So the answer to your question is yes, and that's why I'm just telling the court I'm trying to be have a lot of candor to the court. I have not made any report on it. I would ethically be obligated to, because this has recently, within the last couple days, is when I discovered that the restraining order that was admitted as it was had still contained that 6455, the language that was prevented by 6455. But one of the reasons I brought it up was to look at the total conduct in this case. And I think it's a case where it is so egregious that even under the old standard, I think that Ms. Chandler never had an opportunity at a fair trial from the get-go because of the opening remarks. And then when you compound it with just the character bashing that went on, that even the judge had ruled on several occasions that the prosecutor wasn't going to be allowed to get into certain things because it hadn't been brought up as a 6455 motion. And then with the closing remarks or a closing argument by the prosecutor, I think that this is a case that warrants reversal.
Thank you, counsel. Any
Thank
more
you.
questions? Thank you both for your arguments this morning. The court will take this matter under advisement. Now call the fourth case on this morning's docket. It's case number 118204 in the matter of Matthew Edgar Holt.
May it please the court, the Office of the Disciplinary Administrator appears by Kimberly Knoll, Deputy Disciplinary Administrator. Mr. Chief Justice, if I could reserve 2 minutes for rebuttal, please.
2 minutes is granted.
Thank you. This is an original proceeding in attorney discipline. There were a total of 4 cases presented to a hearing panel. The first one involved multi-jurisdictional practice in Iowa in which the respondent didn't file the paperwork and pay the fee to be able to practice within the state of Iowa under his Kansas license. At the time, he indicated he was leaving Iowa, so they told him it was okay, that he didn't have to do it. They determined he didn't timely leave and shut down his operations, and he ended up being admonished. He did not report that admonishment to our office. The second case involved a request to obtain citizenship for 2 children who were residing in Kenya. In that case, he repeatedly told the clients that the case was moving forward. They were checking with immigration and they were unable to determine whether anything had been filed because it had not. Ultimately, they filed a complaint, he refunded the money, and the representation ended. The third case involved an Australian national who was working in Overland Park. She was here on a work visa that was getting ready to expire. She was going to have to return to Australia for some training and some media and some review. She contacted Mr. Holt and explained that she needed the visa to be able to continue to work. He assured her that he had done many of them, and what he ultimately did was change her status to one that she was a visitor. She was unable to work. She ended up having to go back to Australia in order to get everything corrected. She did ultimately file a civil suit against him. She obtained a default judgment, and then that resulted into a garnishment. And during the temporary suspension hearing before this court, Mr. Holt acknowledged that he has opened up a subsequent account that was not subject to the garnishment. The fourth case involved an individual that was a British-born individual who was seeking dual citizenship. She had 2 concerns, and a British passport. She had 2 concerns. One, she didn't want to cause problems with her American citizenship if she became a British citizen, so she was looking at the dual citizenship, and she wanted the passport. She ultimately did her own research and found out that she didn't have a problem becoming a dual citizen, and her passport application was ultimately declined because he didn't understand the difference between European dating and American dating. At the hearing, he agreed to refund the retainer, part of his retainer that was unearned, and the application fees. The information I have as of August 30th, he made 2 payments totaling $500, so that has not been completed. During the hearing, he stipulated, both before and during the hearing, to all of the alleged rule violations. The issue became disposition. He submitted an untimely probation plan that was ultimately rejected by the hearing panel. There's been no affidavit filed before this court of any kind of compliance as to his proposed probation plan, and I have had no means to be able to confirm whether he has continued with treatment or his association with Kayla. At the hearing, I recommended an indefinite suspension. The panel also recommended indefinite suspension, and here today, I renew that request.
Has there been any, or do you know of any effort, or has there been anything paid towards the
judgment that was entered? Do you know?
I do not know.
Okay.
And just so I'm clear, the judgment that Justice Rosen's, I wrote on my notes here, the $750 filing fee and the $100 attorney's fees paid to CW, and the panel that the respondent had agreed to pay those to CW, but the panel was not aware whether that action had been taken. Do we know whether that action has been
Yes,
taken?
that was what I was referring to. CW has been paid 2 payments that total $500, but not the complete amount that he agreed to pay at the panel.
I'm sorry, I must have missed that. Okay.
Counsel, you made reference to the 2 different accounts, and you said that the respondent made reference to them when he was here on an earlier matter. And there was a garnishment request outstanding on one account, and then he transferred funds from that account to a new account that he established. Am I correct so far?
I carefully reviewed arguments from the temporary hearing, and I do not recall him saying that he had transferred funds. Justice Beyer asked him if there was enough money in the account to pay the garnishment, and at that time it was not known that there was a secondary account, and he said no.
No, there was not enough money in what I call account number 1 to pay the garnishment.
That is my belief of what the test or what the discussion was at the first hearing. And then I believe it might have been it was either Justice Johnson or Justice Siegel that asked about where the client money actually was going. And he said that he didn't have a trust account, that he had opened up a second, I think he used the word checking account or operating account. And the inference was that that was not subject to the garnishment. And then I got up and said, this is the first that I've heard of this second account, and I have concerns that the garnishors are not aware of this account to be able to figure out the garnishment.
And given that, my follow-up question is, are you contending that this was an attempt to defraud the creditor, the judgment creditor?
Mr. Chief Justice, I do not believe Mr. Holt has ill intent. I haven't believed it from the beginning. I believe that he has significant competency problems. I could see a scenario in which he thought, well, my office account is being garnished. There's been all of this discussion about protecting client money. When he was here before, you asked him whether or not he had set up a trust account. He said no, but he would go out and get one. I could see a scenario that he believed that setting up a secondary account was necessary in order to protect client money from the garnishment. Because I do believe that client money is going into whatever he calls this account, because he doesn't have a trust account. And the pattern was that he was accepting funds up front prior to the work being completed. So I can see a situation in which he thought he was doing the correct thing and didn't really give it a second thought that he needed to report that second account to the garnishers.
All right, thank you.
But I will acknowledge, I did suggest that I had concerns that that could have been the scenario because I was so surprised that there was a second account.
The scenario being it
Being
could
there-
have been a
Absolutely.
fraudulent intent.
Absolutely.
Thank you. Any more questions?
I do. I have one question. At page 33 of the final hearing report, when the panel is discussing mitigating circumstances, they state that the respondent provided a response to the initial complaint filed by JWEV and CW. This is under his present and past attitude of the attorney as shown by cooperation during the hearing and full and free acknowledgement of the transgressions. Do you agree with the panel that his response to the JW complaint acknowledges responsibility for the transgressions?
May I go back to council table and get that response?
Sure, and that's at page 14 of the final hearing report, the quote from the response. That's what I'm looking at.
Okay.
I directed you to the mitigation finding first, but the actual extended quote from the response is on page 14.
Now I do recall. I think in Mr. Holt's way, this is how he acknowledges. I think it goes back to more of a competence issue. I don't think he realizes the depth and the breadth of how his actions were not correct and implicated the rules. And I think in his mind, I will give them back their money, even though I did do work, was his way of acknowledging. Did I answer your question?
Yep. Okay. Thank you.
Any further questions? Thank you, counsel.
May it please the court, Matthew Hall, appearing pro se today. And at this time, I'd like to waive my right to oral argument.
Do we have any questions for counsel?
Does that mean you agree with the recommendation of the panel and the disciplinary administrator on the suspension?
Yes, Your Honor.
Okay. Thank you.
Anything else? All right. Thank you, counsel. You're reserved 2 minutes for rebuttal.
Mr. Chief Justice, I would waive unless there's any additional questions.
I see none. Thank you. I thank you both for your comments this morning. The court will take this matter under advisement. That concludes this morning's docket. The court is now in recess until 9 o'clock tomorrow morning.